In the 19th and early 20th century, the Grand Duchy of Finland was part of the Russian Empire. During this time, however, the Finnish people maintained their own separate ethnic identity. When the Russian Empire fell to communism in 1917, Finland declared its independence. The Soviets soon accepted Finnish independence, and the two nations entered into difficult and protracted negotiations about matters such as their borders. One key area of dispute was the area of Eastern Carelia. Eastern Carelia is considered to be the birthplace of Finnish culture, but at the same time its population has long been substantially Russian. After Finnish independence, Finland and Russia negotiated a peace treaty. Under the treaty, Finland gave up control of Eastern Carelia, and in return, Russia agreed to provide for the safety and security of people living in two Finnish communes in that area. Russia also made a declaration relating to its treatment of all people in Eastern Carelia. A dispute emerged as to whether Russia was keeping its side of the bargain. Part of that dispute was whether the Russian declaration was part of the treaty, as Finland said, or whether it was just a voluntary statement and not part of the treaty, as Russia said. Finland took this question to the League of Nations. Finland was a member of the League of Nations, but Russia was not. The League of Nations referred the question to the Permanent Court of International Justice for an advisory opinion. Before the court could even consider the merits of the argument, it first had to consider whether it had jurisdiction to consider the case at all. Russia said that the Permanent Court of International Justice had no jurisdiction because Russia did not consent to that jurisdiction. And yet, whilst the dispute was between Russia and Finland, the court matter was in fact the League of Nations asking the court for advice. In the end, the court felt that it could not proceed to determine the dispute. The court said, "It is well established in international law that no state can, without its consent, be compelled to submit its disputes with other states either to mediation or to arbitration or to any other kind of pacific settlement." From this case, we learn that advisory opinions cannot be used as a clever way to put bilateral disputes before the court without the consent of both parties.